You meant to kill her?
I definitely meant to kill her.
It wasn't an accident?
No, not at all. If I had a chance to do it again, I would.
They were being stripped and raped. Did you both girls or only one girl?
I remember she's dead. They killed Derek. They killed my baby boy.
To the point of I regret being born.
2 weeks before the fatal shooting of Jared Brideigan in 2022, financial records indicated that Henry Tenon, the accused gunman, had a negative bank balance. However, within 2 months after the incident, his financial situation had noticeably improved, with deposits totaling $10,000.
I think this is just, more of connecting the dots. And being able to establish the fact that, there was money exchanged, and the argument will be that the money was for Mr. Brideigan's assassination.
According to documents released by the state attorney's office, these funds came from First Choice Home Rentals, a company owned by Shauna Gardner and her husband, Mario Fernandez. 3 checks were issued to Tenon, all signed by Fernandez, with payments described for tasks such as landscaping and clearing, keeping up with the roof, and a note wishing him Kickstarter good luck. Investigators believe these payments were part of a murder-for-hire scheme, linking Gardner and Fernandez to the crime.
In my mind, I'm like, well, why are they paying him to do housework? If he's just renting a room, to me, that didn't make sense.
And I think it's not going to make sense to a lot of people. I think the defense will obviously argue that, in fact, those monies were paid for legitimate reasons. But I think, because of his background, the relationship that they had, and now the fact that they're giving him large quantities of money kind of lend themselves to be more in line with the state's theory of the case.
Tenon, who had been renting a room in a property owned by Fernandez, pleaded guilty to second-degree murder and agreed to testify against Gardner and Fernandez. Prosecutors argue that the payments were intended as compensation for his role in the crime rather than legitimate work.
They're going to try to explain away a lot of the evidence that the prosecution is going to bring forward. But really, if you just look at this in the grand scheme of things, without Shayna or her husband, it's probably like an impossibility that he would have known Mr. Brideigan or would have ever had contact with him. They are the link between Mr. Tenon and Jared.
Legal experts believe the financial transactions create a clear link between the couple and Tenon, further supporting the prosecution's case. Meanwhile, defense attorneys are expected to argue that the payments were unrelated to the crime and were for legitimate services. Prosecutors are seeking the death penalty for the couple, while the defense team has filed multiple motions to exclude the death penalty. With the trial for Gardner and Fernandez tentatively scheduled for October 2025, more evidence is expected to surface as the case unfolds. In November 2020, Jaro Afo, 28, pleaded guilty to second-degree murder in connection with the death of his cousin, Derek Wiley. According to court documents, Jaro was responsible for Wiley's death and later enlisted the help of his brother, Jordan Afo, to dispose of the body at a scrapyard near Isabella Lake in Shelton. Jordan pleaded guilty to first-degree criminal assistance and unlawful disposal of human remains. On the day of their sentencing, members of the Squaxin Island tribe gathered with Wiley's family outside the Mason County Courthouse in a prayer circle. The gathering honored Wiley's memory and highlighted his importance within the community.
We have a responsibility as Indigenous people to continue to sing our songs, to gather, and to do all of those things, and he was that. He was a young warrior, and he'll never be able to experience that or to fulfill what it was that he was here to do.
Court is now in session.
During the courtroom proceedings, Wiley's family shared heartfelt victim impact statements. His mother, Foster, expressed the immense pain and sorrow she has endured since losing her son.
Because when I first wake up, I don't remember he's dead. Then as I begin to get grounded in my first moments of consciousness, I remember he's dead. They killed Derek. They killed my baby boy.
Foster also voiced her hopes that Wiley's case would encourage improvements within Mason County's criminal justice system.
I feel like the judge heard us today. I feel like the system worked today. And while I understand the system doesn't always work, not just for our people or for people of color, but all people, right? Today, it worked.
Following their guilty pleas, Jero Afo was sentenced to 20 years in prison for second-degree murder. Jordan Afo received a 5-year prison sentence for first-degree criminal assistance, along with an additional 90 days for the unlawful disposal of human remains. Daryl Ditto has been charged with murder in connection with the tragic death of his girlfriend's son. According to Ditto, he was putting the boy to bed when he realized something was wrong and called 911 for help.
As I lays him on the ground, I'm like, damn, dude's stomach ain't going up and down. This is when I realized he wasn't breathing.
Initially, he informed authorities that the boy may have choked on food. However, medical professionals later provided a different explanation based on their findings. During the investigation, Ditto admitted that he had not interacted with the boy for a couple of days and acknowledged that the boy had misbehaved.
I ain't whooped that man since Sunday. So I said, come here, mother. And I grabbed him like this, just like that. I did like I was, you know, I mean, it was a, come here. If I did shake him, I didn't think I shook him that hard.
He explained that he avoided physical discipline due to his frustration.
I didn't do no physical discipline today because I knew I was that angry. I knew I was that angry.
The detectives asked him to demonstrate how he disciplined the boy.
If his head or his brain swole because of that, it was never intentional.
Medical examinations revealed evidence consistent with a condition that can result from forceful movements and can lead to severe health consequences. Based on the medical findings and Ditto's admissions, authorities proceeded with charges, alleging that his actions contributed to the boy's critical condition. His bond was set at $500,000. In December 2018, Randy Teal Jr. was involved in a tragic DUI crash that claimed the life of Sophie Grace Leon Friesenhan. Teal had been drinking at a Jacksonville Jaguars game before driving home intoxicated. Meanwhile, Sophie and her family were returning from a Christmas event where they had taken her first and only holiday photos with Santa. Their vehicle was struck in the collision, leaving an irreparable void in their lives. During court proceedings, Sophie's family shared the profound grief they have endured since the crash. The family displayed photos from that fateful night, highlighting the precious moments stolen from them.
The minutes, hours, seconds, days leading up to this moment.
Because of the hurt that I've caused so many people in this family, to the point of I regret being born.
Teal took the opportunity to address Sophie's family directly in court, offering an emotional apology. He admitted full responsibility for his actions and expressed deep remorse.
I take full responsibility of every single hurt, suffering, cry, tear, moments that you could not sleep, moments that you didn't know what to do next.
He acknowledged the suffering he caused and wished he could undo his actions.
And that's why I took flowers and balloons to Sophie's memorial site. Yes, I have watched from a distance everything the guys has been going through.
His family, including his father, also spoke in his defense, emphasizing that Teal had never been in trouble before and that he too had been deeply affected by the incident.
My head tells me his apology is heartfelt, but I feel like forgiveness for him and accepting his apology will come later.
Sophie's family acknowledged his remorse.
Given the totality of the circumstances here, in my judgment, the appropriate sentence is 14 years. That includes a 4-year minimum mandatory.
Despite their heartbreak, Sophie's family acknowledged that the sentencing marked an important step in their healing process.
I do not forget every moment. I'm so sorry.
In August, Teal pleaded guilty to charges of DUI manslaughter and DUI causing serious bodily injury. During sentencing, the judge considered the severity of the case and the totality of the circumstances. Ultimately, Teal was sentenced to 14 years, with a mandatory minimum of 4 years. A Westchester County courtroom was filled with emotion as Jaime Paucar faced sentencing for a devastating wrong-way crash that took the lives of 57-year-old Jordan Wachtel and 18-year-old Eric Goldberg. The incident occurred in January 2020 when Paucar, with 3 prior DWI convictions, drove under the influence on II-287, colliding head-on with the victim's vehicle. Wachtel, his son, and a friend were on their way to a basketball game when their car was struck. Tragically, Wachtel and Goldberg lost their lives, while survivor Jack Rosen sustained serious injuries.
I mean, I think about it every day. Like, I don't sleep at night. Like, I miss my best friend.
During the sentencing hearing, Paucar expressed deep remorse for his actions, acknowledging the pain he had caused the victims' families. However, his words did little to comfort the grieving relatives, who shared their heartbreak and the lasting impact of their loss. They spoke of the void left by their loved ones and the enduring emotional toll the tragedy has taken on their lives.
All of these victims and their families, friends, and community will remember what the defendant did to them for the rest of their lives. And all of this because the defendant drank alcohol and got behind the wheel of a car.
Every day, I pray for those who died.
Despite Paucar's defense attorney highlighting his role as a husband and father of 3 in a plea for leniency, the judge remained firm.
Mr. Paucar should have known better.
The court ultimately sentenced Paucar to the maximum penalty for aggravated vehicular homicide, requiring him to serve at least 8 years in prison before becoming eligible for parole. This case marked a significant legal milestone, as it was the first instance in which the Westchester District Attorney's Office pursued a murder charge in a DWI case, although Paucar was convicted on the lesser charge of aggravated vehicular homicide. Coben Porter, the younger brother of NBA player Michael Porter Jr., was charged in a fatal DUI crash that claimed the life of Katharina Rothman. At the time of the incident, Coben was a basketball player at the University of Denver. The tragic crash deeply affected both families. Katharina Rothman's loved ones shared emotional victim impact statements in court, speaking about the void left by her passing. They described her as a kind and caring person whose presence could never be replaced. The loss has left an indelible mark on their lives, and they emphasized how difficult it has been to move forward without her. Coben Porter's family, along with a pastor and a counselor, also spoke at the hearing, offering insight into his character and the remorse he has shown since the incident. Over 55 letters of support were submitted to the court, detailing Coben's positive contributions and expressing hope for his future. His older brother, Michael Porter Jr., expressed his heartache, saying he wished he could have taken his brother's place instead.
Second thought was, man, not Coben. Like, out of anyone in my family, there's no way Coben is going through this. You know, like I said, he's the one that, out of all of us, he's the one that doesn't deserve to have gone through that. And even though he made choices, you know, there's a lot of people in life who make bad choices, and it doesn't end up the way it did for Coben. I remember during the whole process, I was just thinking, man, like, I wish it was me.
Coben himself admitted that he once believed nothing could happen to him, but now deeply regrets his choices and wishes he could undo what happened that night.
It's so hard for both families. I mean, our hearts, we'll always have pain in our hearts, and we're always going to miss my Katharina. And but I think we feel peace now.
Despite their grief, Katharina Rothman's family acknowledged Porter's remorse and stated that they have found some peace in knowing justice has been served. Porter was sentenced to 6 years in prison. In addition to this, Porter was also ordered to serve 3 years of mandatory probation. Erwin Recinoszuniga, 26, was charged with 3 counts of DUI manslaughter and 3 counts of vehicular homicide following a devastating crash in Miami that resulted in the deaths of 3 individuals.
Sir, you were arrested for DUI manslaughter, 3 counts.
The incident occurred when Recinoszuniga was allegedly driving at 78 miles per hour in a 40-mile-per-hour zone along West Flagler Street while on his way to a club with friends.
We haven't had a case such as this in a while.
According to investigators, the group had been drinking from midnight until nearly 3 a.m. before deciding to leave. Reports indicate that Recinoszuniga had consumed 5 to 6 shots of whiskey before getting behind the wheel. Shortly after, his red Kia crashed near a gas station situation, leading to the fatal outcome.
They were drinking from midnight until 2:50 in the morning when he made the decision to get in the car with his passengers and drive to a club.
Authorities believe that both excessive speed and alcohol impairment were significant factors in the crash.
He was under the influence of alcohol, which may have been the contributor to this crash. He was driving at a high rate of speed. That too plays a big role.
During his court appearance, Recinoszuniga's defense attorney argued that he was not the driver at the time of the accident. However, prosecutors presented evidence from a detective's investigation that confirmed he was behind the wheel. A circuit judge found probable cause and set his bond at $105,000. Additionally, the judge ordered him to surrender his passport and prohibited him from driving.
It's a very unfortunate situation, and the message that we always want to reiterate to drivers: if you've had one drink too many, make sure to hand off your keys or just be responsible.
In a surprising turn of events, Recinoszuniga was deported to Honduras on September 6, 2024, before facing trial. Miami-Dade Corrections released him to U.S. Immigration and Customs Enforcement, ICE, without notifying the court or the state attorney's office. In April 1991, sisters Julie and Robin Carey were walking on the Chain of Rocks Bridge in St. Louis, Missouri, accompanied by their cousin, Thomas Clemons. That night, they encountered 4 young men: Reginald Reggie Clemons, Marlon Gray, Antonio Richardson, and Daniel Winfrey. What started as a chance meeting ended in tragedy when the Carey sisters fell into the Mississippi River and drowned. Clemons initially told investigators that a group of young men had forced his cousins off the bridge and then coerced him to jump. However, during questioning, he was pressured into implicating himself and was briefly charged with their murder. Further investigation cleared Clemons, shifting attention toward Clemons and the others. Clemons was arrested on April 7, 1991, and during interrogation, he reportedly confessed to being involved in the assault but denied responsibility for the deaths. The case led to multiple trials. Marlon Gray was convicted in October 1992 and sentenced to death in December of the same year. Clemons' trial began in January 1993, with a jury consisting of 10 white jurors and 2 African Americans. He was found guilty on February 18th and sentenced to death on April 2nd. Antonio Richardson was also convicted and sentenced to death in July 1993. Daniel Winfrey, the only white defendant, took a plea deal, testified against the others, and was later paroled in 2007. As Clemons' execution neared, his case drew national attention due to concerns about police misconduct, racial bias, and an allegedly coerced confession. In 2002, a U.S. District Court judge overturned his death sentence, citing jury selection issues. However, in 2004, the ruling was reversed on procedural grounds, reinstating the sentence. In 2009, the Missouri Supreme Court halted Clemons' execution and appointed a special master to review his case. Clemons retracted his confession in 2012, claiming it had been coerced through police violence.
Judge, there's been injustice at every point along Reggie's road to death row. When the police picked him up for questioning, they told his mother that he didn't need a lawyer and that she couldn't come with him. 19-year-old Reggie had never been in trouble with the police. Now he was alone with them for several hours, and he was beaten by his interrogators.
I remember Browers had stood up and grabbed the back of my chair, and he slid my chair back against the wall. And there was some more statements like, we'll bounce you off these walls and we're gonna make you talk and you're gonna tell us what we wanna hear. At one point I was looking at Brower while he was talking to me, and Pappas had grabbed me by the neck and slammed my head against the wall. They were hitting me in my chest area. When I was sitting down, they was hitting me more in my upper chest, but when they stood me up, they was hitting me in my side and in my sternum.
I want to show you Respondent's Exhibit I. Do you recognize that as your booking photo?
I guess it is.
I want to show you Exhibit J. It's also your booking photo, isn't it? You've got on the same orangey red shirt, was taken when you got arrested.
Yes.
There are no injuries in these pictures at all, are there?
Yes, there's The right side of my face is a little bit swollen.
Well, let's look at this. Show me an injury.
I can't see it too well from here.
And you can't see any swelling or injury at all in that photograph, can you?
But it was there.
At his arraignment 2 days later, Judge Michael David noted visible injuries on Clemons and ordered a medical examination, which confirmed bruising and inflammation. Despite this, the prosecution proceeded with the case, relying heavily on Clemons' disputed confession and statements from co-defendants. During the trial, Clemons invoked the Fifth Amendment when asked about the details of the crime, refusing to answer whether he had harmed the victims.
Is it true, Mr. Clemons, that the girls were fighting while they were being stripped and
Under the advice of counsel, I plead the Fifth.
is it true, Mr. Clemons, that one of the girls told the other one not to fight and not to resist? You
Under the advice of counsel, I plead the Fifth.
Did you both girls or only one girl?
Under the advice of counsel, I plead the Fifth.
You understand the inference I will draw from your refusal to answer those questions?
Yes.
You understand I will take from your refusal to answer those questions that your testimony would be unfavorable to you.
The courtroom was emotionally charged, with the victim's mother visibly distressed as she faced the man she believed was responsible for her daughter's deaths. She expressed frustration over Clemons' claim of innocence, stating that he had already confessed and should be held accountable.
He confessed to killing my children 21 years ago, and now all of a sudden he's innocent? He's poor Reggie? Gee, I wonder if my kids were hurting when they were being beaten and raped, their clothes being torn off of them in the cold night by strange, horrible men who meant them no good. He needs to be executed. He executed my children, did he not?
After years of legal battles, the Missouri Supreme Court vacated his conviction and death sentence in 2015, citing prosecutorial misconduct and concerns about the credibility of his confession. Facing a retrial, Clemons accepted an Alford plea in December 2017, maintaining his innocence while acknowledging that the state had enough evidence to convict him. He was sentenced to 5 consecutive life terms without parole, ending nearly 3 decades of legal proceedings. Sean Mickey Stines, once a trusted sheriff of Letcher County, Kentucky, was at the center of a shocking case in September 2024 when he was accused of killing District Judge Kevin Mullins. Kevin Mullins had served as the district judge for Kentucky's 47th Judicial District since 2009. Before becoming a judge, he worked as an assistant Commonwealth's attorney. Originally from Pikeville, he had built a respected legal career and was known for his commitment to justice. Stines, on the other hand, had been elected as Letcher County Sheriff in 2018 after working as a court bailiff. He was re-elected in 2022, further cementing his authority in the county. Tensions between the two men had been brewing for some time. In 2022, a lawsuit was filed against one of Stines' deputies, Ben Fields, by a woman named Sabrina Adkins. The suit accused Fields of using his position to coerce female inmates into inappropriate acts in exchange for favorable treatment while on house arrest. Disturbingly, some of these incidents allegedly occurred inside Judge Mullins' chambers.
He does have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls and stuff.
What describe? Have you seen the videos?
I've seen one partly, and just him having with girls for their bail to get out of jail.
Who was having?
Ben and just some higher ups up there.
Who?
The judge and.
Now you saw the video.
Mm-hmm. Yeah.
What did you see on the video? I mean, you.
I mean, I've seen Judge Mullins have sex with a girl.
Who was the girl?
I don't know, because I don't know a lot of people from over.
Where was it at?
In his office, in the judge's chambers.
Is that the same place that you were meeting Ben? Is that how you know it was a judge in chambers? Yeah. And this was Judge who?
Mullins.
The lawsuit also claimed that Stines failed to properly train his deputy and ignored reports of misconduct. There are chances that Stines was also involved in the same kind of misconduct.
You saw the video of the judge.
Yes.
Any other videos that you actually saw?
No. They say that the Sheriff Vicky Stines is involved. I don't know.
Who said that?
Chad. He said he had videos with Mickey. And Mickey used to do the same thing when he was over house arrest.
Just a month before the shooting, Stines had testified in relation to the case, placing him under further scrutiny. On September 19, 2024, at around 3 p.m., Stines entered Mullins' office inside the Letcher County Courthouse in Whitesburg. The two men spoke privately behind closed doors. Moments later, gunshots rang out. Court staff rushed to the scene only to find Mullins fatally wounded. Meanwhile, Stines walked out of the courthouse and surrendered to authorities without resistance. Following his arrest, he was charged with the first-degree murders of a public official. When he appeared in court in November 2024, he pleaded not guilty. The death of Mullins may have connections to Stines' daughter. On September 19, 2024, after having lunch together, Stines and Mullins returned to the courthouse. Surveillance footage reveals that before the shooting, Stines attempted to call his daughter using both his own phone and Judge Mullins' phone.
I was told that Sheriff Stines had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
So, have you obtained the phone records from Judge Mullins' phone?
I don't have those in my possession yet, no.
Okay. Have you issued a search warrant for them?
Yes.
Okay. And have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins' phone?
Yes, I believe so, yes.
So that number had been called from Judge Mullins' phone?
Yes.
Is that correct?
Yes.
Surveillance footage of the shooting was also shown in the court.
Taking, is that a portion of the video?
Yes, it is.
This sequence of events suggests that discovering his daughter's contact information on the judge's phone might have contributed to the subsequent confrontation. The exact nature of the relationship between Judge Mullins and Stines' daughter remains under investigation. Authorities have not confirmed any inappropriate conduct, and the motive behind the shooting is still being explored. Defense attorney Jeremy Bartley has indicated that the shooting was not premeditated but occurred under extreme emotional disturbance, implying that Stines acted impulsively upon discovering unsettling information. As the legal process unfolds, prosecutors expect the discovery phase to take 4 to 6 months, while the defense continues reviewing documents. Stines has filed an affidavit of indigency, which may allow him access to Chapter 31 funds for legal expenses, including private investigators or expert witnesses.
And then next, are we in a position to know if there's going to be a request for any type of evaluation?
Judge, I've spoken with my client. I thought you were speaking. So what we have spoken with Mr. Steele about is that we do believe that there will be an issue as to criminal responsibility. We have consulted with folks with regards to that issue. I reached out to Mr. Steele and we basically decided that we would raise this as a joint motion. I know that, once we provide that notice, the Commonwealth is entitled to have their expert evaluate Mr. Stines, and out of expediency, I believe that Mr. Steele and I would ask for an order for that evaluation to go ahead and take place. There are a couple of issues I did want to address with regard to the examination. I don't think they will be at issue at all, but I did want to make a couple of notes. But that's how we intend to proceed, Your Honor, with the court's blessing.
Officials are also considering a criminal responsibility evaluation to assess his accountability for the crime, potentially including an insanity defense. Additionally, a competency evaluation may be conducted to determine if he can understand and participate in his trial. No dates have been set for these evaluations. Mitchell Blair, a mother of 4 living in Detroit, Michigan, became the center of a horrifying case in 2015 when authorities discovered the remains of her daughter and son in a freezer inside her apartment. Blair lived in a small townhouse with her daughters and sons, Gabby, Stoney, Stephen, and her youngest son. Financial difficulties led to her losing stable employment, and she relied on government assistance to support the family. Her struggles grew as she withdrew them from school, claiming she would homeschool them. In the summer of 2012, an incident involving her youngest son set off a chain of events. Blair claimed she found him engaging in inappropriate behavior with dolls. When she questioned him, he allegedly told her that his older brother, Stephen, had been mistreating him. Angered by the revelation, Blair confronted Stephen. She later claimed that he admitted to the actions, though there was no official evidence or investigation to confirm this. Over the course of 2 weeks, Blair took matters into her own hands, punishing Stephen harshly. He eventually succumbed to his injuries on August 30th, 2012. Several months passed before another accusation arose in May 2013. Blair now alleged that her daughter, Stoney, had also mistreated her youngest son. Again, instead of involving authorities, she resorted to severe punishment. According to Blair's later confession, she confronted Stoney, who she claimed admitted to wrongdoing. On May 25th, 2013, Stoney lost her life under similar circumstances. Rather than reporting their deaths, Blair chose to hide what had happened. She placed both of them in a deep freezer in her living room, continuing to live in the apartment with her 2 surviving daughter and son. To avoid questions about their absence, she pulled them out of school and told others that she was homeschooling them. For nearly 3 years, the tragic secret remained undiscovered. It wasn't until March 24th, 2015, when court officers arrived to evict Blair for unpaid rent that the truth came to light. While clearing out the apartment, officials opened the freezer and made the shocking discovery. Blair, who was present at the time, immediately admitted responsibility. She expressed no remorse, stating that she believed her actions were justified.
Okay, I just have a few more questions. When you were physically harming Stephen, was it ever your intent to also cause any sort of serious mental harm?
Well, I don't understand what you mean.
When you were hurting him physically, was it also your intent to cause any sort of serious mental harm?
What do you mean, mentally damage him?
Yes.
Like beating him in the head?
No, like making it so that his thoughts aren't right.
No,
Does
never.
that make sense? Okay.
Physical punishment on what you did to my child, because I had always told my kids the worst thing you can ever do to somebody is rape them. I always told my son that, and I always told the girls the worst thing you could do is cry rape on somebody if they didn't rape you. They fully knew what they were doing.
So you were only intending physical punishment?
Yes.
All right, now, just so that I'm clear, you weren't allowing them to treat your other children like this, were you?
What do you mean?
You weren't allowing them to assault.
I wasn't allowing that.
Right,
I never knew.
That's exactly,
you get what I'm saying?
That's exactly what I wanted to know. You didn't know until afterwards.
It's like...
Am I right?
Yes.
Okay.
It's this one instance, I was asleep. Why you didn't tell me? He said, Mom, I even ran in the hallway and I had your hand. I was asleep. My son ran out and grabbed my hand. He was 6 and he was doing like this, trying to wake me up. Stephen was grabbing him back by the back of his shirt, pulling me, and I said, why didn't you just scream out? He said, I don't know. You get what I'm saying? He even had my hand pulling on me, trying to wake me up. And since I'm a hard sleeper, I didn't wake up. So to hear my son say that to me is real up that shit happened right up under my nose. So, man, I don't regret none of this. I don't regret any of it. It's my son. That's my baby. There's no way that his brother and sister should know what he feels like inside. There's no way.
Understood.
I don't feel no remorse for the death of them demons.
Following her arrest, Blair was charged with multiple serious offenses, including first-degree murder, felony murder, child abuse, and torture.
Ms. Blair, what did you do to Stoney Blair that makes you guilty of premeditated murder?
She raped my son. I intentionally killed her.
How did you do that?
Starting from the beginning, when I found out about what Stoney was doing,
It was 9 months later after finding out about Stephen. So for the whole 9 months we were in the house, she was still raping my child. I did not know that. When I first found out, after told me, I took a minute because I was not understanding, you know, what was, that she did that to him. But I repeatedly pushed her. On many occasions, my son, I told him to tell me every single thing she did to him. So as she was telling me, he was telling me more and more things that she did. I assaulted her every time he told me what she did to him. By assault, I mean I punched her. I have put a bag over her head till she lost consciousness. I threw hot water on her, scalding hot water from the faucet.
Did you hit her in the head with a wooden stick?
Yes, I hit her head multiple times, over and over.
Was that shortly before she died?
That was actually days before she died and the day she died.
Okay.
I hit her on her back. It's like on her tailbone. I kicked her.
Okay, I just want to clarify a few things. And perhaps you don't know, but did this happen on or about May 25th, 2014? To the
May
best of your
25th is actually the day she died. Well, the day I killed her.
And you said you killed her by putting a grocery bag over her head?
Yes, that day would tell me different things because she was doing this to him for years, and I did not know that. You get what I'm saying? And I didn't find out till 9 months later. She had started with Stephen. She ruined my son, okay? She started with Stephen before he even started. So, yes, I put a bag over her head, but it got worse that day. Yes, I did. It got worse that day because he would tell me how she would take her pad, her menstrual pad, and squeeze her out in his mouth, okay? And it was just, it was over with after that. It was over with.
You meant to kill her?
I definitely meant to kill her.
Okay. It wasn't an accident?
No, not at all.
Okay.
If I had a chance to do it again, I would.
When you went and got the grocery bag and suffocated her, that was your intent?
Yes.
Okay.
She was standing in the bathtub. I was throwing water on her. My son was standing to my right outside the bathroom door, and he was telling me everything he was telling me. I looked at her and I'm like, "You did this?" And she was like, "Yes." So I actually had a stick and I was hitting her in the head. Every time he told me something, I hit her very hard in her head, and I was throwing water on her. And when I actually took her out of the bathroom, I took her back in her room, and I just kept staring at her, and I said, excuse my language, to him, just like, you know, I'm constantly asking her. She kept saying, "I hate him." And I'm like, "You hate him?" You know? And she admitted to me that she hated Stephen. She hated everybody. And I'm asking her why. She says, "'Cause everybody always thinks so cute." And I'm like, "So you brother," because you get what I'm saying. So I meant to. I definitely meant to. And I do not feel any remorse for what I did to Stoney, because she had no remorse for what she did to my son. And it's not only him, she gang him with Stephen. We're all sitting on the floor, and he was telling me, this is how I found out about both of them doing it together. But it was too late. Stephen was gone. But told me that Stoney would actually make him sit there while, in his words, her and Stoney did the nasty stuff, and then they did it to him. And
so this was your way of inflicting punishment?
Definitely.
Okay. Where did that happen?
What?
Where did it?
The death.
Her actual death?
Yes.
Not
the location of the house. Where did you live at the time?
Oh.
Is that in the city of Detroit?
Yes.
Okay.
Your Honor?
Go ahead.
Can we ask Ms. Blair if she ever actually saw or witnessed any of these acts with regard to Stoney or Stephen?
Okay. Yeah. Did you ever actually see anything of any sexual abuse of any kind between either Stephen and Stoney?
I reject her question, but I will answer it because no one will say that this did not happen because it actually did.
I just want to have a clear record. Because so far, all you've told me was that you just heard it. Did you ever
And
actually
that they
see it?
admitted it. No, I did not. You get what I'm saying?
Yeah, no, I
But
understand.
as I went back in my head and thought back to all the many things that was wrong with you over the years, and I'm like, that's what was wrong with you? He'll use the bathroom and say, Mom, my hurts when I poop. I don't know. So I started giving him 100% juice to make his stool softer, maybe to help him use the bathroom. That wasn't the problem. It wasn't his stool. It was that he was being raped, okay? My son looked me in my eyes and he gave me a very detailed account of everything they did. Is not a violent boy. He is a very sweet little boy. So for him to stand there and look at me and say, do it again.
Throughout the court proceedings, she repeatedly justified her actions, claiming she was avenging her youngest son.
That's the evidence, Your Honor. No physical evidence that that younger child was physically abused. No eyewitness to physical abuse, or sexual abuse in that child, but abundant evidence that he was physically abused, as was his surviving sister, by this defendant. People have nothing else.
Okay. Mr. Harris, is there anything you'd like to say before I give your client an opportunity to speak?
Yes, Your Honor.
Go ahead.
I have had an opportunity to speak with Ms. Blair over a couple months. Her story has not changed. It has been consistent as to the abuse that her younger son admitted, and the other two children who are now deceased have indicated that they committed on this young boy. So I don't know where the prosecutor is getting that this didn't happen, because they did not interview the younger boy. I will indicate to this court, and believe me, I don't justify Ms. Blair's actions. It can't be justified, and she understands that. But this is a horrible situation in which you have an individual who was abused as a young child, experienced hardships, lack of education, had children. Children did some unspeakable things to each other. With the lack of support that she had as a child, and the lack of support that she had from any of the fathers of these people, and I'm not making an excuse for her, but that didn't allow her to cope with the situation in a way that many of us would have obviously chosen different options. What angers me the most, I think, is no way in the world, as a father, I would allow anybody to not let me see my children for years. There are always options. They could have asked for a welfare check with the police.
However, prosecutors said no medical or investigative evidence supported her claims that abuse had occurred by her daughter and son, but the defense countered by saying that no one asked the boy who was abused.
You had the opportunity to make your own decisions with respect to running your own life, and you were blessed with 4 children. Stoney and Stephen are never going to have that. They don't have those same opportunities. And when I think about all of the possible joys that they could be missing out on, one thing that strikes me as the greatest tragedy here is that they will never know what a life is like without experiencing fearing their mother. They will never know the joy of what could have been in their life without having you in it. They lived in terrible fear of you. And I find that just so sad in this case. After all is said and done, you imposed the death penalty on your own children.
I did.
And you readily admit it, and you want to take responsibility of it. You're therefore sentenced to the Michigan Department of Corrections for the rest of your life without the possibility of parole, meaning, of course, that you will never get out. You will receive, yes. You will receive credit for 115 days. You must pay $60 DNA fee, $136 state costs, crime victims assessment in the amount of $130, court costs in the amount of $1,300, attorney's fees in the amount of $400. These are not consecutive sentences because you weren't advised of that. at the plea taking procedure. Since this was a conviction by plea though, ma'am, you have the right to file an application for leave to appeal your conviction.
I don't need any of that.
Okay.
In June 2015, she pleaded guilty to all charges and was sentenced to life in prison without the possibility of parole. The surviving daughter and son were placed in the care of relatives and provided with counseling to help them process the trauma they had endured. A routine morning at a South Carolina elementary school took a troubling turn when a teacher discovered a loaded handgun on a student's desk. The student had taken the firearm from his grandfather's home and brought it to school in his backpack. When questioned, he innocently stated that he wanted to shoot zombies, showing no awareness of the potential danger. Fortunately, no one was harmed. The quick response from school staff and a resource officer kept the situation contained within the classroom, preventing a lockdown. Investigators traced the gun back to the student's grandfather, Kalim Abdul Alawajid. Authorities alleged that he had failed to store the firearm securely, allowing his grandson to access it. As a result, he was arrested and charged with unlawful conduct toward a child.
This morning around 7:50 a.m., a faculty member of the Lawrence Elementary School observed what appeared to be a small frame handgun on the seat of a student's desk. The faculty member then immediately notified school administration and the school resource officer, who then took possession of the firearm. There was never a threat made toward any other students or staff, and due to the quick action by faculty and school resource officer Ted Richardson, this incident was contained to one classroom and no lockdown needed to be declared. The student that brought the gun was then taken from the class, and the investigation began from there on where, how, when, and why the student came to be in possession of the gun. That part of the investigation is still ongoing. However, it was quickly learned that the student found the gun at his grandfather's residence, and that individual, identified as Kalim Abdul Alawajid of Lawrence, has now been arrested and charged with unlawful conduct toward a child. Mr. Alawajid will have a bond hearing tomorrow morning at 8 a.m. The Lawrence Police Department commends the staff of Lawrence Elementary for their quick action in this matter, and it is because of the excellent working relationship that the Lawrence Police Department and the District 55 have that this very serious situation was handled quickly and in a professional manner with no injuries or further incident.
During his court appearance, he was informed of his legal rights and the option to apply for a public defender if he could not afford one. His bond was set at $40,000.
All right, in regards to bond for unlawful conduct towards a child, the bond is $40,000. This is a cash or surety bond. You will need to post it to get out. Do you think you're going to get a bondsman?
I'm poverty stricken at this time. I'm on Medicare and Medicaid. I don't have access to a bond.
Well, what we will do is we'll allow you to sign your bond form. Should you or your family get a bondsman, then they can come take care of the paperwork with us and you'll be released. On the first form, I need you to initial at the X. On the second form, I need your signature at the top, and I need you to read out loud D and initial it.
D. Other condition, the defendant will comply with the following other condition of release, shall report to the bonding agency on a weekly basis, shall not be arrested for any other offense while out on bond, should not have any contact with the victim in person, third party, social media, Snapchat, Instagram, etc.
Okay, and I need you to initial it. So basically, you're not to have any contact with the alleged victim directly or indirectly.
My grandson. Ma'am, can I ask you a question?
As long as it's not about your case, you can only ask me questions about the bond hearing.
Yes, ma'am.
Okay.
I got a lot of physical illnesses, and I can't be in jail. I can't take my medicine because they say my medicine is a controlled substance. I got a lot of medicine. I got prostate cancer. I need to be out.
Okay, well, hopefully you can post bond and get that taken care of.
I mean, I ain't got nothing to post bond with, man. I mean, could I possibly be out on personal reconnaissance bond?
No,
I got
sir.
a lot of animals I have to feed every day. I got a pasture full of animals. I ain't got nobody to feed them.
I understand that, but no, sir, you cannot have a PR bond.
Is it the nature of my offense? The reason why I can't have a PR bond?
It is.
Okay.
Any other questions?
No, ma'am.
All right, have a seat.
I just would like to be able to get in touch with somebody, make a phone call.
All right, we'll make sure that you get a phone call.
Okay.
In court, Alawajid expressed concerns about his health, mentioning that he had medical conditions that required ongoing care. He also stated that he had several animals at home with no one to care for them. He requested a personal recognizance bond, hoping to be released without payment, but the court denied his request due to the severity of the charges.
We acknowledge that our children are of the utmost importance to us, and their safety is paramount in any situation such as this one. We encourage parents to take proper precautions by securing any firearms in the home, and to have conversations with your children about proper safety and the use of firearms, and to maintain an open dialogue with the child about safety and any concerns that they may have. And remember, prevention begins at home.
The incident raised concerns about safety and parental responsibility. Superintendent Ameka Thomas urged parents to regularly check their daughters' and sons' backpacks and have conversations about firearm safety. Law enforcement officials emphasized that firearms are not toys and must be stored securely to prevent them from accessing them. In December 2019, a tragic shooting took place in Spartanburg County, South Carolina. 19-year-old Carrion Devontae Garrett was arrested in connection with the death of Knowledge Jamarian Geeter.
Okay, Carrion Garrett. If you will step right up, please. Okay, Mr. Garrett, you are here on 5 charges. The first charge is murder, and that can carry from a 30-year prison term to life. Okay? The second charge is possession of a weapon during a violent crime, and that can carry up to a 5-year prison term. And then you have 3 attempted murder charges, and each of those could carry up to a 30-year prison term. So do you understand the 5 charges that you have against you and the maximum penalties you may be facing?
Authorities charged him with murder, possession of a weapon during a violent crime, and 3 counts of attempted murder.
There. So, this time, we'll consider bond. Now, first must inform you that on the first charge of murder, that by state statute, I am prevented from setting bond on that charge. That must go to a general sessions judge. Okay? Now, on the next 4, I am allowed to set bond on it. However, again, whatever I do there, you're still here until you go to a circuit court for a bond hearing on the murder charge. You understand that? Okay. Well, I've read over the incident reports and looked at your record and got information from you, and considering all that, I do find, based on the charges, that you are at risk for attending your hearings, and you are an unreasonable danger to the community and are some individuals. So you will be getting a cash surety bond, okay? And I'm going to go through each one here and designate an amount. Now, on the possession of violent crime, possession of a weapon during a violent crime, which can carry up to a 5-year prison term, I'm going to do a $5,000 bond on it. And I'll explain how bond works, if you'd like for me to, when I finish this. All right, the murder conviction is being sent to General Sessions Court. Now, on the attempted murder charges, those can each carry a term up to 30 years. I'm going to set a $20,000 bond on each one of those. Okay? So it's going to be a total of $65,000 bond on the 4 charges excluding the murder. All right, I'm also going to institute a no contact provision with any of the victims or any of the victim's immediate family. Okay, there's no contact with any of those individuals.
During his bond hearing, the judge explained that state law prevented the court from setting bond for the murder charge, meaning it had to be addressed by a general sessions judge. However, a cash surety bond was issued for the other charges, totaling $65,000, $5,000 for the weapons charge, and $20,000 for each of the 3 attempted murder counts. A no-contact order was also imposed, barring Garrett from communicating with the victims or their families. In January 2020, Garrett filed a complaint about conditions at the Spartanburg County Detention Center, claiming overcrowding and unfair administrative segregation without a disciplinary hearing. He also reported being without legal representation since dismissing the public defender assigned to his case. 3 years later, in May 2023, Garrett sought a writ of habeas corpus, arguing that he had limited access to his attorney and had received inadequate legal assistance. He also alleged that his rights had been violated regarding attendance at grand jury and preliminary hearings. However, the court recommended dismissing his petition, citing ongoing state proceedings and the availability of other legal avenues within the court system. As of March 2025, Garrett remains in pretrial detention with his case still pending. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.